if the 4 p.m. deadline passes and the government decides it's not going to comply in full with the ruling by Baroness Hallett, then in theory, they could be committing a criminal offence under the Inquiries Act, and criminal proceedings could be taken. Another option is that the Baroness Hallett could refer the matter to the High Court, and the High Court would then make an order deciding what to do next. And then a third option is that the government could tell Baroness Hallett that they're going to judicially review her, and they have until next week, early next week, to do that, because it's only 14 days from the decision that was taken. And if they decide to judicially review her, it's unlikely that any enforcement action will be taken in the meantime, but that would be heard, I suspect, pretty quickly by the High Court.
Boris Johnson has said the request for his WhatsApp messages and the diary entries could breach government rules on disclosure because of national security issues.
I don't think national security is the issue here, because I think, from my understanding of the ruling, Baroness Hallett accepts that certain elements would not be provided to her on a national security basis. I think it's the other things. It's the material which isn't connected directly to the COVID response. But Baroness Hallett says, I want everything related to everything that was happening in that period, because I want to see what pressures the Prime Minister was under and his officials, and what other issues they were dealing with, to get the full context of what was happening during this extraordinary crisis. So it's a very wide request and quite an unusual one, but one that Baroness Hallett says, well, I know I'm the decider of relevance, and because of the extremely unusually wide terms of reference that I have, I really do need to see everything to get the full picture.
And as we were saying, there is precedent. Previously, it wasn't a judicial inquiry, it was a public inquiry, the Chilcot inquiry, but the committee was told that it would be able to request any British document and call on any British citizen to give evidence. But we were just debating that with our previous contributor, saying that that was back in 2009. That was before WhatsApp messages. People are much more easy to speak to each other, much more open, one might say, with each other on something like WhatsApp. Does something like that need to be taken into account?
Well, there's nothing unusual in the court and inquiry system of seeing WhatsApp messages. They've been, and text messages generally have been, they're disclosable, they're relevant. If they're relevant documents, they need to be disclosed to courts, and they are as a matter of course. I mean, in lots of cases that I'm involved in with the government, you see messages, because that's, as you say, a lot of the time, that's how public officials communicate to each other. The sort of wider question is, in the context of an all-encompassing emergency response, which the pandemic was, it wasn't a usual sort of public issue where there would be parcels of time and meetings devoted to it. It was, you'll remember, it dominated the news, it dominated everything for 2 years. You could barely get to do anything else without it involving COVID. And I think when you've got a series of WhatsApp messages between government officials during that period, a lot of it will be relevant because of context. But also, I think the other thing that Baroness Hallett is worried about is that she's not, if the government decides what's unambiguously irrelevant, which is the words that it's using, she doesn't trust that will encompass everything she needs. So in the example, what they did to prove to her, or to try and prove to her that they were doing a good job, they provided a short section of messages which was unredacted, to say, look, we've given you everything in the previous bundle of documents, we've given you everything that we should have. And she said, well, actually there were messages that you redacted that related to the police response to the Sarah Everard vigil, which was all about the COVID rules. So that's not a good start, and not a promising start, she said in the ruling. And I think that's the other main reason that she's not willing to allow the government itself to be the decider of its own of relevance. She says, I'm the decider of relevance, I'm the inquiry chair, I have a much better understanding of what I need to be worrying about than you do. So I think that's where she's coming from, and that would be the issue, or the justification that would be presented to a court if it ever goes to court.
That's interesting. What's your best guess on what's going to happen, Adam, before I let you go?
I've absolutely no idea. I mean, it's not a situation I've seen before. It's not the width of the request is, I think, unprecedented, or at least close to unprecedented in a public inquiry. But I can entirely see the logic, because the COVID pandemic itself was unprecedented. So we are in, legally speaking, untested waters, which is why the government will be really worried about setting a precedent of having to give everything, even documents which don't relate to a particular crisis, to inquiries. So they may be willing to take the public risk of challenging it, and we'll see what happens.